Hello everybody, welcome to iExamBee's LegalBee. This is Amrita, your law faculty at iExamBee. In this video, today I'm going to discuss with you all the recent landmark judgments passed by the Honorable Supreme Court of India from 1st of April to 15th of April. This is an exclusive series only at LegalBee that is discussing landmark judgments from all the 15 days. Every 15 days, you will be getting a set of landmark judgments from the Supreme Court of India and also some high courts that are relevant for you in your judicial exam preparation, or else if you are a practicing advocate तो आपके लिए ये सारे judgments काफ़ी काम के हो सकते हैं. The ratios in these judgments will be very helpful for you people. So don't forget to subscribe to our YouTube channel and stay updated with all such kind of beneficial content. Landmark judgments from 1st of April to 15th of April. The court has had a lot of holidays, so keeping that in mind, there was only 3 to 4 working days, and that's why the number of judgments are comparatively less as we get every 15 days that are very landmark. I am picking for you, so take account of all these judgments. I would suggest अगर आपने पहले के videos भी नहीं देखे हैं आप वो भी जाकर देख लें. सीरीज़ इसका एक प्लेलिस्ट आप चेक कर सकते हैं लीगल बी पर जाके. दैट विल बी डेफिनेटली हेल्प यू, एंड आप इन सारे पीपीटीज को डाउनलोड भी कर सकते हैं एज यू विल गेट अ रिकॉर्ड ऑफ ऑल द इम्पॉर्टेंट केस लॉस. NTPL लिमिटेड वर्सेस मेसर्स SPML इंफ्रास्ट्रक्चर लिमिटेड. ये 10th अप्रैल को जजमेंट पास किया गया है बाय द ऑनरेबल सुप्रीम कोर्ट. इट इज़ रिलेटिंग टू आर्बिट्रेशन एंड कंसीलिएशन एक्ट. दिस वाज एन अपील which is arising against the decision of the High Court of Delhi, which has allowed the respondent's application of constituting an arbitral tribunal as per section 11 clause 6 of the Arbitration and Conciliation Act. But इस judgment में जो appellant है उनका क्या कहना था, that the application for arbitration is an afterthought and there is abuse of the process of arbitration, of a legal process. And the Supreme Court has ruled in favor of the appellant that High Court has made an error over here. The High Court of Delhi has erred in not examining the falsity of the dispute. It is an afterthought. So courts should have exercised the prima facie test to screen and strike down the ex facie meritless and dishonest litigations as well. So ये judgment काफ़ी important है arbitration के point of view से. Central Bureau of Investigation versus Vikas Mishra @Vikas Mishra. This is another special leave to appeal which has been filed by the CBI before the Honorable Supreme Court, and it is against the grant of default bail. आपको पता होगा default bail statutory bail का provision है section 167 CRPC में. अगर इन्वेस्टिगेशन टाइम पर कंप्लीट नहीं होती है, डिलेज अलॉट 90 डेज से ज़्यादा हो जाता है एंड चार्जशीट ही फाइल नहीं हो रहा है, तो ऐसे केसेस में डिफ़ॉल्ट बेल दी जाती है अक्यूज्ड को. सो द सेशंस कोर्ट डिनाइड स्टेटूटरी बेल and High Court granted statutory bail to the accused. So CBI came to the Supreme Court against the order of High Court of Calcutta of granting default bail. The ground that they have taken is that the police custody of the respondent was only for a period of 4 days. Actually वो 7 days के लिए रिमांड थी, but the respondent accused could not be in the custody for 4 days, यानी कि इन्वेस्टिगेशन पूरा नहीं हुआ था. एक्चुअली ये उस जजमेंट का क्रक्स है दैट इंटरोगेशन के लिए उन्हें कस्टडी की और ज़रूरत है. सो द CBI रिक्वेस्टेड द ऑनरेबल सुप्रीम कोर्ट दैट जो पीरियड हमें नहीं मिला है फॉर इंटरोगेशन, पूरा 7 डेज़ का पुलिस कस्टोडियल रिमांड वाला पीरियड हमें इंटरोगेशन के लिए नहीं मिल पाया था. सो डिफ़ॉल्ट बेल शुड नॉट बी granted and that order of High Court of Calcutta should be set aside. So this was kept into account and Supreme Court has ruled in favor of the CBI. CBI versus Aryan Singh, another judgment, special leave to appeal that has been filed by CBI only again, and that is against the judgment and order of the High Court of Punjab and Haryana. Punjab and Haryana High Court has used its powers under section 482 of CRPC and has quashed the criminal proceedings under section 452, 323, 365, 342, 186, 225, 506 and 120B of IPC. इतने सारे sections के FIR criminal proceedings को quash किया गया था against the accused Aryan Singh. So CBI challenged this order and went to the Supreme Court. Supreme Court has ruled in favor of CBI and has held that the High Court has committed an error. that the initiation of criminal proceedings is malicious. Whether it is malicious or not, that is a part that cannot be, that should be considered, and the same is required to be considered at the conclusion of the trial. You cannot just cause the proceedings without and just be judgmental at this stage. That is what is we can understand in for our understanding from this case. In any case, at this stage, what is required to be considered is a prima facie case should be there, and whatever materials collected during the course of investigation have warranted the accused to be tried, then the High Court has exceeded in its jurisdiction in quashing the entire criminal proceedings. This was the conclusion of the Supreme Court, and the order was therefore set aside. Ajay Shankar Srivastava versus Bar Council of India and another. This is another very recent judgment. ये काफ़ी न्यूज़ में भी है अभी, because in this case what has been done, the State Bar Council of India को एक order दिया गया है जो Supreme Court ने इस केस में दिया है, that the genuineness of the degrees of the practicing advocates need to be verified now, and इसके लिए committee भी constitute करनी चाहिए that should regularly check the degrees, because many advocates many people are practicing with fake degrees as well. So ये नहीं होना चाहिए. It is a danger to the administration of justice to the citizens. This was observed by the court. Shiv Mangal Ahirwar versus State of Madhya Pradesh. Again a judgment from criminal law. In this particular case, the Sessions Court had convicted the appellant for offence under Section 302 and Section 149 of IPC. There were 3 co-accused as well. They were using deadly weapons and have committed murder. So after that, when the High Court also confirmed the sentence, one of the appellant challenged his conviction that his identification was itself in doubt. Identification of accused was doubtful. This was the ground that he had taken, and he also relied on a judgment of the Constitution Bench of the Supreme Court in Union of India versus Sri Haran Elias Murugan and others. तो आप ये केस लॉ भी नोट डाउन कर लीजिए, क्योंकि ये काफ़ी इंपॉर्टेंट जजमेंट है इस पॉइंट पर. That Sessions Court is not having any jurisdiction that the appellant shall undergo imprisonment for the rest of his life. क्योंकि इस केस में Sessions Court ने for the rest of life का imprisonment impose किया था as a punishment to the accused. So this ground was also taken that the Sessions Court is not having this power. So this was considered by the Honorable Supreme Court, and the Honorable Supreme Court has modified the order of conviction. Not completely set it aside, but modified the order of conviction that there is gravity of the offence. So we need to impose a fixed term of sentence. High Court should have done that. High Court has actually justifiedly done that. So what the Supreme Court has held that for a period of 30 years, the appellant deserves to be imprisoned, and the conviction of the appellant under the impugned judgment was upheld, and it was held that rigorous imprisonment for a fixed period of 30 years should be imposed on him as a punishment and not imprisonment for life. B.S. Hari Commandant, Union of India and others versus Union. B.S. Hari Commandant versus Union of India होना चाहिए. In this judgment, the Supreme Court has again set aside the order of conviction of a commandant of the border security force. The conviction has been upheld by the Punjab and Haryana High Court as well. सो उस वजह से उसके सारे रिटायरमेंट बेनिफिट्स भी चले गए थे. द पर्सन हु ही वाज सर्विंग इन द आर्मी एज द BSF फ्रॉम 1969. In 1995 he was charged for smuggling cases as he was staying on the borders. So at that time he was charged under NTPL Act. So उस वजह से उसका सर्विस के जो उसको रिटायरमेंट बेनिफिट्स मिलने वाले थे वो भी चले गए थे. सो द हाई कोर्ट हैज़ ऑल्सो नॉट हाई कोर्ट के सामने भी वो गया था विद अ क्रिमिनल रिट पिटिशन अगेंस्ट हिम दैट ही शुड बी द क्वॉशिंग ऑफ क्रिमिनल प्रोसीडिंग शुड बी कैरिड आउट. दिस वॉज हिज प्रेयर एंड ऑल द रिटायरमेंट बेनिफिट्स शुड बी रिस्टोर्ड. बट द हाई कोर्ट हैज़ ऑल्सो dismissed his petition. So thereafter he approached the Supreme Court, but the Supreme Court has observed that just on one person's statement and no other material evidence against him was found. So therefore In this case, you cannot just result conviction of that person on one person's statement. That was what was the substantial part that we can make out from this judgment. So his conviction was set aside and all the retirement benefits were restored back to the border commandant. Javed Ahmed Hazam versus State of Maharashtra. This is a judgment of the Bombay High Court. Bombay High Court has refused to quash FIR against a professor. He was a Kashmiri professor and he had kept a status on WhatsApp for abrogation of Articles 370 is a black day for Jammu and Kashmir. Now, on this, an FIR was filed against him. Section 153 of A of IPC is attracted over here. So what court has observed that we cannot quash this FIR because this message has a tendency to play with emotions of different groups of people in India. So this has to be handled very cautiously and consequences of this can be actually very harsh. Means इसके वजह से काफ़ी सारे लोग भड़क सकते हैं, बहुत कुछ ऐसा हो सकता है जो नहीं होना चाहिए in the country. So for the peace of the country and this FIR proceedings cannot be quashed. This was rightly held by the Bombay High Court. State of Kerala versus Sriram Venkatram and Wafa Nazim at the rate Wafa Firoz versus State of Kerala. So in this case, the High Court of Kerala has set aside the order of Sessions Court. Sessions Court had discharged accused number 1, who was an IAS officer, who was Sriram Venkatram, and he was discharged of the charges for culpable homicide under Section 304. But the High Court of Kerala has restored back those charges. Actually, he was charged also for rash negligent driving and along with that driving in drunken state and also for damage of public property. Motor Vehicle Act के भी sections उसको लगे थे. Along with that, his wife was also charged under abatement. His wife is Firoz. So the Honorable High Court has actually caused the charges against his wife Firoz because she did not intentionally aid, instigate or conspire. So abatement के sections उस पर नहीं लग सकते. This was held in this particular judgment and 304 was restored back because 304 was attracted over here because if you are driving in a drunken state, so you can be attributed the knowledge that the consequences of your driving, of your actions can lead to an accident of an innocent person. ये knowledge आपको attribute किया जा सकता है, was held by the High Court of Kerala. ये भी काफ़ी important ratio है, I would say. Rash or negligent driving on a public road with knowledge of the dangerous character of his act, especially when he drives in a inebriated state, can fall in the category of culpable homicide not amounting to murder if the injured has died as a result of the injuries. So that's why I've taken this judgment as it is very landmark one because it is dealing with the ratio and how we can attribute knowledge under section 304 of IPC. So this was all that I had to discuss with you all about the recent landmark judgments. Stay tuned with iExamBee's LegalBee. Don't forget to subscribe. अगर आपकी कोई भी queries हैं, you can write to us in the comment section of this video as well. And also you can write to us at hello@iexambee.com. You can call on this number and visit our website for more details.